Right. I can see people are still joining, but let me, on behalf of Sullivan and Worcester, welcome you to the July webinar. I'm Geoff Wynne and I'm presenting today's webinar. For those of you who'd like a break after this webinar, we are taking a summer break and we'll be back in September, and we'll keep you advised about that. So today's webinar is entitled, Have We Made It to Digital Trade Transactions? And perhaps those of you who've been following what's been going on in the press and so on may not be surprised that the word digital is in this presentation. But let me tell you now my approach to today. Next slide, please. So it's a natural starting point to look at the Electronic Trade Documents Act, which has just received royal assent and will become effective in a couple of months' time. And therefore, I am indeed going to ask the question as to what it's done and what it's not done. But then I'm going to look at that wider question, is can a digital trade transaction be completed and who wants to do it? Because that's actually had me thinking, because a digital trade transaction is by definition a trade transaction completed digitally. But the trade is actually a supplier and a buyer. In other words, not the financiers, not the platform. It's actually the commercial parties. And what I want to look at is how we can do that and whether it can be completed in whole or just in parts. And then I'm going to look at this question from various perspectives of the different participants. I'm going to take us through what is now going to be doable under English law and indeed what was doable, and also to look at how other jurisdictions are approaching this matter, then to look at what's being done, to ask the question of what's holding us back, and then perhaps to summarize the present and future and see if you agree with my conclusions. So let's move to the next slide, please. The Electronic Trade Documents Act, described as a game changer by many, including me, and it certainly is. Because as you will see from the ramifications of this, whilst if you look discreetly at the Act, you may say, hey, what's the fuss? I think you'll start picking up what's going through here. So ETDA, as I call it, allows for the legal recognition of certain trade documents in electronic form where previously they could not do so. But there's a split in the list of the trade documents. Documents are titled to goods, like bills of lading and warehouse receipts. A couple of key documents, like bills of exchange and promissory notes, which evidence payment, and then some other interesting technical documents, which I'm not going to spend too much time on. The concept of what we're doing, though, is the ability to speed up and indeed to boost trade. And one of the key elements of that is the less need for paper documents. The key that ETDA has brought about is to make, by law, certain electronic documents that can be possessed electronically in the same way as if they were a paper document. Possession then means that not only can you possess it, but that you can therefore transfer it. And transfer in some ways is a key element to this, even though it might not actually be your intention at the time you create the electronic document to need or want to transfer it. But the point is, if you comply with the Act, an electronic document, it says, will have the same legal effect as a paper one. Next slide, please. To put this into perspective, MELITA, the Model Law on Electronic Transferable Records, has been implemented by a number of countries. This is the UK's way of adopting Melita. What it does is provides flexibility within English law. And as many of you will have heard me speak and other lawyers speak, English law is actually very flexible and allows interpretation to move with the times. But some changes were necessary, as you will see, to bring, if you like, the law up to date with what might happen. So in order for an electronic document to have the same effect, you need to have possession. And that's exclusive control, is how possession of an electronic document would be evidenced. And how that would be evidenced is in a reliable system, which can, as you can see, identify the document as original, protect it from unauthorized alteration, is secure that only one person can have exclusive control at any one time, the ability to demonstrate the exclusive control and to allow it to be transferred. What does that mean in relation to a reliable system? Next slide, please. So the Act identifies a reliable system in concept. It's technology neutral and offers no concrete definition of a reliable system. It sets out guidance on what courts would consider if the reliability was disputed. And there's a list here which I won't read out to you. You can just read that at your leisure. But a couple of points on this is, first of all, the fintechs who have been talking to us and to others about wanting to establish a reliable system, you should note all of these points, because these will be criteria against which your system will be judged. It's quite likely that the courts may well turn to expert witnesses or indeed lawyers to help support an interpretation of a given system as to whether it is reliable. Now, one of the questions that's being asked is, do we need more? Some jurisdictions, Singapore, for example, are looking at having registries of reliable systems. We are currently not going down that route, but one suggestion that's coming from the ICC is to have an ISO, a document, a standard against which a system would be judged on that. France is also looking at following a similar path to us as having specific documents, but is also going further, and I want to come back to this point, on involving other parties in the determination of reliable systems and the use of electronic documents, and indeed looking at other laws around this, like data sharing, which, as many know, is a potential problem under English law, and we need to deal with that. But there is an issue at the moment that the Act, as it currently stands, may leave the market wondering how participants can be certain there is a reliable system available at all times. And I think for the moment, we are certainly going to document agreement as to reliable systems by contract, because English law will allow us to do that. And again, let's bear that in mind as we look at the use of ETDA as we move towards the digital trade transaction. And that takes me back to my first point. Next slide, please. So how would you want to complete a digital trade transaction? What are the requirements? Well, a supplier and a buyer at least have to evidence their sale and purchase by way of electronic records. Bear that point in mind. They can still have their supply contract, they can still actually have invoices or whatever. But ultimately and conceptually, a seller sends an electronic record evidencing the goods sold and how it's being delivered. The buyer would accept the order and become obliged to pay on delivery. In other words, when the two parties have agreed, the buyer or someone else on the buyer's behalf will pay. Now, we have rules for this, as I'm going to remind you about. But one of my first questions is, does the market want to do it? What is the market in this? And the point is, do suppliers and buyers themselves want to achieve a digital trade transaction? Or is there such an attachment to paper? You've heard me before. You know, I love the feel of paper, the smell of it. I don't want to part with that. And one of the points is, how do you break away from having paper into a more paperless world? Is there a distrust of data matching? And I use the phrase without human intervention, because I believe that may well be a recurring theme that we need to look at as we move forward. And therefore, I will ask you the question of, how can we achieve the correct balance between moving towards the paperless trade, but at the same time, not having machines totally dictating what's going on? So let's have a look at the discussion on that. Let's have a look at some perspectives of various parties. Next slide, please. In some ways, if you forgive me, this is a slightly tongue-in-cheek look at how the players in the marketplace might view what is going on. Not unsurprisingly, since I am delivering this talk, I start off with the lawyer's view. Now, from a legal point of view, we can now have a paperless digital, i.e. a digital trade transaction. The law, in many ways, is ahead of technology. And in any case, we can always do this by a contract. The parties can always agree a contract under which they will recognize a digital instrument, a paperless instrument. The legislator, of course, will turn around and say, here it is. I've given you ETDA. What more do you want? The point I've mentioned here is there are other laws, of which I've picked two, that adversely affect how we might want to complete a digital trade transaction. The first is confidentiality. We need to be able to share the information, to share the data. And of course, GDPR, which runs contrary to data sharing. And as I mentioned, France is also looking at this. But at the moment, if we are not careful, as we go down the path without dealing with the ability to share information, to make information available to platforms and so on, we are in danger of continuing what I call the fraudster's charter, the ability of the fraudster to play off the fact that parties do not talk to each other. Now, the regulator, you've heard me before say the regulator needs to start embracing what we're talking about here. The general view from the regulator is you cannot rely on technology. Consequently, particularly the parties it regulates, banks and financial institutions, are required not solely to rely on technology. So the question then is it safe to do a digital trade transaction if the regulator is not happy about it, if the legislator has not changed the laws? We'll look at that in a minute. Of course, the fintech position is we have the solutions, and we will see certainly in proof of concept, interoperability of the different systems is a problem that needs to be overcome. Some of the fintech providers say, we can do this, we can sort this for you. But of course, some of them say, well, you don't need to worry about it. Just stay with us, stay with our system, and you'll be fine. Next slide, please. Let me turn to a number of you listening in, the banks and the funders. Certainly, historically, banks and funders have very much worked towards digitalization of certain aspects, but generally speaking, only for their own customers, using their platforms, other approved platforms, and signing contracts for the use of the platforms with customers that they know, where they have gone out to other parties. They've made investments in specific solutions, and of course are looking to recover that investment in supporting those platforms and structures that they're working with. I might say, of course, interoperability is not my problem, because in fact, I want to keep everybody working with my documents, my contracts within my system. But then, of course, the most important parties on this, the customers, the suppliers and the buyers of goods. And they're the parties that may well turn around and say, well, why should I do it? At the moment, I can buy and sell goods without moving into this digital world. What's in it for me? Can I afford the cost of the technology that you want to force on me? And perhaps I'm happy where I am. So we need to look at that, because as you'll see, my view is that if we really are going to digitalize the trade transaction, you have to start with the trade transaction, with the supplier and the buyer. So what do you think? What do you fit into all of this? There's a Q&A button, there's a chat line, and I'm certainly happy to pick up points a bit later on. Let's move on, please, the next slide. So some of these questions I posed and statements below, are these correct? The market remains happy with the paper world for much of the trade that it does. And consequently, the cost of investment into some of the technological solutions holds the parties back. Changes in law facilitate the move to digital trade, but what I call things, and we'll look at those in a moment, may well hold back full digitalization on that. As I mentioned, the regulators do not embrace the technological solutions. We need to get around that. We need to persuade the regulators to allow solutions that have in some ways been approved to be used within our trade transactions, so we can indeed speed them up. I'll come back to the verification of identities, because KYC is clearly a problem if we cannot verify the identities. What else is being done? Well, there's quite a lot that is being done, as you will see, and other things that clearly can be sorted. And my view is that ETDA can be the catalyst for this, because English law, by enacting the ETDA, is leading the way. It behoves all of us working in this marketplace to get it right as we move towards paperless trade. But we need to be careful that we don't move headlong into this without considering the steps that we need to take and how best we can take them. So what's the current position? What's currently going on? Next slide, please. Well, there's a lot going on in the UK and indeed in many other jurisdictions, with the changes of law that are coming on, driven by embracing Melita, driven by pandemic, the lockdown, the need to move paper more quickly. There's always been a lot of activity in the supply chain, the receivables market, lots of platforms offering receivables and payables solutions. Electronic invoicing has been going on for a long time. And so the ability to buy an invoice, to discount an invoice has always been there. There have also been club-based solutions. I put letters of credit and electronic bills of lading in some ways in the wrong order. We have electronic letters of credit solutions, but electronic bills of lading within clubs have been around for more years than I care to remember. But the club-based solution, as I describe it, is a contract between all the members. So all the members join a particular system, a particular platform, and they agree to accept a particular digital document, which can therefore be transferred between them. And ultimately, what would happen is that when you needed a paper copy, paper version of the document, particularly the bill of lading, you could require it, and that would be fine. So that will still be available. Fintechs, of course, are offering lots of other solutions. I mentioned sanctions because sanctions is an issue. The tracking of goods, the tracking of ships, the issuance of guarantees. All of these are definitely possible when you sign up to particular platforms and particular solutions. Indeed, as one of my clients said, banks like electronic instructions. They don't particularly want paper. But of course, whose risk is any electronic instruction? The customer's risk. But we can move this into trade. But what we need is to help to educate both banks, customers, and the providers as to how we should move forward. But there are plenty of contractual solutions available even now and in the lead up to ETDA taking effect. The use of electronic payment undertakings, which will then be supplemented, possibly replaced by what I call ENIs, electronic negotiable instruments. In other words, the promissory notes and bills of exchange that will come out of ETDA. And of course, using electronic bills of lading will become possible when the Act takes effect. So let's have a look at what is actually doable now. Next slide, please. I'm looking at this from an English law point of view, but actually what I say may well apply in a number of jurisdictions, but absolutely may not apply in some very key jurisdictions. It's always been possible to do much in the digital world. Electronic signatures, for example, have been recognized for a long while in the UK and in the EU and in other jurisdictions. The EU has EIDAS. We have concepts of some sort of electronic signature, qualifying electronic signatures, and as many of you know, systems like DocuSign, so we can sign our documents digitally. The requirements for documents to be in writing can be satisfied in a number of ways under English law, not just paper. And that next bullet point, smart contracts, click and agree, recognized as binding. Many of us do it a lot of times when we log on to things, when we buy things, and so on. So we can do a lot electronically. We created, before the change in law, the electronic payment undertaking, the ITVA electronic payment undertaking initiatives launched in April 2020 was an example. The idea being to create an electronic payment undertaking that would mimic exactly how an electronic negotiable instrument would take effect, just working out how to transfer it on that. But what is available now to facilitate the whole of the digital trade transaction and the payment for it? Next slide, please. Some of you may have heard me talk about this before. The uniform rules for digital trade transactions. This was an ICC initiative that I was proud to work on that looked forward to the digitalization of trade, but some people said, not yet. What we said is that you still need to document and perform a trade transaction, but you could evidence it using electronic records. Against quite a lot of opposition, the rules were published and became effective on the 1st of October 2021. We would see it just as part of the move towards digitalization. And it was designed, if you like, to focus the minds of parties as to how you could create the evidence of an electronic way of a digital trade transaction. Next slide, please. So the first thing was, how could you use URDTT? The phrase we used, electronic records to evidence the digital trade. That wording came out of Melita, is part of what comes out of EDTA. And what it did was it set out the rules, how to create a payment obligation of the buyer. In other words, the buyer said, I will pay for these goods. And where that was agreed, a financial service provider, bank, financial institution, or anybody else who wanted to lend credit support or replace that payment obligation with its own could join in that transaction. Was it ahead of its time? Well, perhaps it was, but surely now is its time. With what is going on around the world with Melita, implementation with ETDA, this is the time perhaps to have another look at using URDTT within your trade transaction. The human element is something that perhaps when I look back on how we approached the data approval process, we should have been more mindful, and perhaps we should remain mindful of the need to deal with human intervention to sign off. Let's come back to that point a number of times. But let's look at how you would document a trade transaction under URDTT. Next slide, please. So the way we saw it is parties will still sign their terms and conditions, but they will evidence performance by agreed electronic records. Their sale and purchase would incorporate URDTT, and consequently, on data match as defined, the payment obligation would arise. That payment obligation could be undertaken by an FSP, could indeed be a letter of credit, could indeed be a payment, some other form of payment undertaking. And URDTT contains provisions about responsibility for that electronic record, corruption of data, force majeure, and the parties are then free to agree the method by which the data is provided. And of course, that takes you back to a reliable system that can be designated in relation to the contract. So I ask the question, is it time, or is the timing, is this worry about the immediacy of data approval that holds matters back? We can deal with that. But does this generate a digital payment obligation? Absolutely. That's the whole point. And that digital payment obligation can be the electronic promissory note or the electronic bill of exchange, which ETDA supports. So what do we do with a digital payment obligation? Let me tell you. Next slide, please. So following on from URDTT came what I call URTPO, Uniform Rules for Transferable Electronic Payment Obligations, launched by ITVA in December 22. Why have it? Let me explain. Its focus, if you like, its starting point was we have URF 800. For those of you who don't know that, URF 800 are the Uniform Rules for Forfeiting. And what they looked at is how you would complete a forfeiting transaction, which itself generated a payment obligation, which could then be traded. So URTPO, if you like, does not fit in with URF 800 because it does not look at the origination of a transaction, but it definitely looks at how a transaction in forfeiting or anywhere else could be used by market participants to transfer it. So let's move on to the next slide. So what's the relationship with other rules or indeed ETDA? Well, the answer is some or none, because what we're talking about is a system, rules or whatever, that creates an electronic payment undertaking, electronic payment obligation, which can then be transferred using the uniform rules. So you need a digital payment obligation created somewhere else, but then you can document how that payment obligation can be transferred using a mixture of electronic records, paper, or both, because examination is key to the driver of URTPO. The buyer wants to know exactly what has happened before it buys that payment obligation. But you have a transfer document with a governing law, and that incorporates URTPO. Next slide, please. So what is outside the rules? The creation of an electronic payment obligation. Then you deal with the transfer using the rules. That needs a technology solution. The magic is the reliable system on which the payment obligation will reside and can therefore be securely transferred. ETDA covers this. It creates electronic promissory notes and electronic bills of exchange, and they are perfect payment instruments to use with URTPO. I'll come back to that because you can see a revolution coming here, perhaps. Next slide, please. Let me move on to another very helpful development. You all know about letters of credit. Many of you will have seen EUCP as the supplement and digital companion to UCP 600, which deals with documentary letters of credit. It was designed to move parties from paper documents to electronic records. The latest version is important. 2.1 has just been launched by the ICC. It reflects the alignment with Melita and ETDA. In other words, it extracts specifically how you would deal with electronic records payment obligations. It's key if you want to use a letter of credit, which many of you work with electronically already using Swift MT700. This can be used. This is another move forward in the digital world. I've seen only today that using a platform, a digital letter of credit has been used. It's all coming together in our digital trade world. What else should we look at? Next slide, please. I want to mention this point again because it's something that strikes me in the world of KYC, that it's something that ought to be moving much quicker. Legal entity identifiers has been around for quite a long time, have been well supported going back to 2014. You can see the statistics, know who you are dealing with. So not just necessarily KYC, your direct customer, but what about KYCC? How can you do this? And the answer was, as suggested, simple, cheap, and easily accessible online with annual renewals. But there's work that needs to be done to help with KYC in order for businesses to see the need to register with a recognized system. So the cost, and the question is, how do we say this will be worth your while to do it? And who is going to bear that cost? I leave that with you. That if you like, is a policy matter, is not mine to solve. Next slide, please. My point is, though, that LEI plus ETDA opens up digitalization of trade internationally. It can make it much more efficient, much less paper-based. It's not me that's saying that. The ICC and others are talking about the sort of savings that can be made using this. National campaigns are required to promote the adoption of LEI, not well adopted in the UK, I confess, but perhaps because we have other means of identifying corporates, we may need it less, but certainly rolling this out into SMEs in other markets, in other jurisdictions, particularly emerging markets, may well be another answer to how we can move towards the digital trade transaction. Next slide, please. I thought I'd take a quick look at lots of things are going on in the fintech world. Fintechs are already working on interoperability, but I might say in some ways to suit their customers, to suit the needs of their particular offering, their particular platform. But we are seeing in proof of concept at the moment how an original document in electronic form can be transferred by creating a new original on a new platform. And consequently, remember what I said about exclusive control. You have to invalidate the previous original on the old platform and validate the new original on the new platform on that. Ownership has to transfer between the platforms, and that will need to be dealt with. If you remember, in reliable systems, auditability is available, but the question will then be, is it reliable? Can you rely on it? And that consequence of that is a need to understand what an auditable ledger will provide, and therefore, can you trust the information that is being provided? That takes you back to how we work with reliable systems on that. A question, do the two platforms have to decide to be interoperable in order to do so? I think that is going to be the case, or we can deal with it between the parties who would then agree that the move from system 1 to system 2 is agreed, and that system 2 will then be the magic sole source of truth. Other jurisdictions, Singapore, are looking at interoperability among several platforms on that. And the ICC is going to develop a bilateral proof of concept and move that on to multilateral interoperable concepts. So there are lots of things that can happen in the world of interoperability, but at the moment, we can still work with fintechs, with their systems, bearing in mind the legal requirements. Next slide. So what should we do? What should you be doing? I think we have to recognize that there is the need to speed up processes. But one of my questions is, which process? There is a need to use less paper. It's good for the environment. But does that mean we need to go paperless? Not necessarily, perhaps not at all. Perhaps there will be contracts, there will be legal documents around in paper, in printable form on that. And consequently, using digital solutions, you need to take care on that. The good solutions will facilitate this, but there's no requirement to make this mandatory. It'll be optional. It will be choice that you can use. And what is going to happen is that the law, EUCP, for example, ETDA is another one, will move us along, and other systems will do that. One question for you is that if we embrace the payment obligation part of ETDA, will that change payment obligations in the underlying trade transaction to shorter unconditional ones? Remember, ETDA addresses promissory notes and bills of exchange. They are unconditional promises to pay either by the issuer of the promissory note or by the acceptor and the drawee of a bill of exchange on that. Consequently, if you have a short form unconditional payment obligation that meets the requirement of the Bills of Exchange Act 1882, that's a very good way, if buyers are happy, to evidence the payment obligation in a trade transaction. You don't therefore need a speedier payment, because we know that supply chain solutions can deal with that, but the certainty of the payment obligation generated digitally using the Bills of Exchange Act will be crucial. So consequently, where we stand now is the ability to create and transfer certain specified electronic records under English law, which of course takes me, if you like, full circle back to Lolita and its ethos relating to electronic records being transferable and the need for each jurisdiction to decide which electronic records it is prepared to recognize. Remembering that one of the driving forces in the UK for the ETDA was the fact that a vast number of transactions are governed by English law, that a vast number of obligations are governed by English law and can therefore take advantage of the electronic solution. And indeed, in bills of lading, a huge percentage, I think some say 80% of bills of lading are themselves governed by English law. This really is opening the way to getting to digitalized trade. What holds us back? Next slide, please. So in the next few minutes, let me just have a look at the sort of things that is holding us back. It seems clear to me that challenges of compliance, particularly in the banking and financial institutions sector, is holding this back on that. And coupled with that is KYC, the definition of who is a customer in a trade transaction, and the extent to which, when you have KYCC requirements, i.e. know your customer's customer, how much due diligence of your customer you can rely on. How far down the road do you have to go within a transaction to identify and satisfy yourself that the underlying trade transaction itself is one that you can be involved in, one that you can finance, for example, on that. This is made even more complicated by the growing use of sanctions as a political weapon on that. So how do you keep track of sanctions? Well, I know some of the fintechs who are online here may well say, come to us, we can give you sanctions tracking. But the problem is that sanctions are going down to not just the parties that you contract with, but the vessels that they use, the goods that are on there. And consequently, it becomes more and more difficult to track your sanctions on that. And is that going to hold back the level of trade that we finance, the level of trade that we're prepared to digitalize? There is also concern, continuing concern about fraud. I mentioned that before. And I have to say that, if you like, the legal digital solutions were not designed to eliminate fraud. What the legal solutions are designed to do is to facilitate the use of digital records, electronic records, with digitalization of trade. Now, fintechs will often say that they can do this, that the risks that I list of double invoicing, non-existent goods can be helped by registers and so on, details of goods. The problem we've got is that if we wait for registries, if we wait for some of these solutions, that will hold back our ability to do more and more trade. That's not a good solution. It's part of the solution. And my point remains that there are other actions that we need to encourage legislators and regulators to take. And I have picked, as you know, two key areas. The duty of confidentiality, which it should be possible to, if you like, breach or work through by consent, so that information regarding goods, the financing of a particular consignment can be shared, and equally GDPR, that data can be shared without a sanction on the party sharing, because that will take us towards the solutions. As I mentioned before, from what I can see, if France rolls out its equivalent to ETDA, it may well address some of these other issues. My encouragement to those who listen to this is to persuade regulators and the legislators to create situations where we can share the important data in a trade transaction to avoid things like the fraud. The other point that holds us back is this balancing of the continuing need for human invention. And that should be built in to any digital solution, because I am as convinced as I can be that having a purely electronic solution, data matching, needs more within what we do. So permit the use of electronic documents, encourage them, but realize that in some ways you need to turn data back into readable form on that. It's not just data, it's how that data is stored. And sometimes it will be required that you need a paper document. You need to be able to get it. Remember that we're looking at that single source of truth, be it an electronic record, be it paper, or be it something that has to be in readable form. But remember, everything that we are doing to move us forward, the regulators and the legislators may well still think trade finance is risky, even though most of us on this call probably don't on that. We don't need to leave hostages to fortune. So what do we do? Next slide, please. The focus is clearly on digital solutions for trade and trade finance on that. That's around the globe on that, described by the ICC. We are at a tipping point, and I think that is right. It is important to strike while the iron's hot. Let's move forward now on looking at the digital solutions. But is there a risk that we would be over ambitious in saying we will today digitalize all trade transactions? And I think that is over ambitious. I think some solutions that are being offered in the market may well be being oversold. Some may not pass beyond proof of concept. Remember that they rely on contract, and contractual solutions will always be available. And so a mixture of contractual solutions with digital solutions may well be our way forward. There is an ability to use what is available. Take that, legal solutions and fintech solutions, and they can be used and should be used to speed up trade and a move towards paperless trade. But we move along that path. AI artificial intelligence should not replace the human element entirely within trade transactions, within the payment for a trade transactions, i.e. letters of credit, i.e. purchasing of digital payment obligations. I do not believe that in this marketplace we are yet ready to rely totally on machine readable data, and nor should we be. I think, as I moderated a panel a few weeks ago, the general consensus around the people in the room, the fintech providers, the compliance people, is that we're not ready to pension off those working in trade, particularly those who check that there's a compliant presentation on the letter of credit and so on. So my conclusion is perhaps we're not ready for the total digital trade transaction, but we are moving there. And the encouragement to all of you is to embrace these solutions so that we can certainly see various elements within trade and trade finance that we all know and love, embracing these digital solutions. I look forward to being with you on that. And I thank you for listening. I have a question that's been asked. If anybody wants to ask on the Q&A or on the chat, please do so. It's interesting, how does the Bill of Exchange Act or the Geneva Convention accommodate Melita? Well, the answer is, somebody said assimilation. The Electronic Trade Documents Act deals with the Bills of Exchange Act 1882. The legislators of the most fantastic piece of legislation in 1882 were not far-sighted enough to look at how you might possess a digital instrument. The Electronic Trade Documents Act simply says that it will give effect to, if you like, a compliant digital document as if the same effect to it as if it were paper. So we can now use a digital bill of exchange or promissory note under the Bills of Exchange Act on that. The Geneva Convention follows, this is the Convention of 1930, adopted by many civil jurisdictions, but not by common law jurisdictions like the UK, US, and so on. I believe that the Geneva Convention follows something very similar. Therefore, if you are in a jurisdiction that uses the Geneva Convention, you need to make sure that how you incorporate Melita will allow you to have the in writing satisfied in exactly the same way. Yes, having a recognized digital document, exclusive control and a reliable system will reduce fraud. That must be right on that. But we're dealing in ETDA and indeed in Melita with selected documents. We're not dealing with the parties or the underlying trade. All that has got to be dealt with. And that will indeed, that will take a bit of time, but yeah, we are moving forward. A question's been asked about how would you enforce a judgment under ETDA in other jurisdictions? Well, the answer will be, presumably, and this is quite important. I have argued for many years that promissory notes and bills of exchange issued under the Bills of Exchange Act should have a governing law and should be English law. I think if we want to use the Electronic Trade Documents Act, we should issue promissory notes and bills of exchange under English law. That will naturally mean that we will look at if there is a legal action brought in the English courts, and then we'll look at reciprocal enforcement on that. Remember, you still have to be satisfied that the party who is obliged under the digital instrument can accept that obligation on that. There's a place, sadly for many of you, for lawyers to help sort that out as well. And comments just come, interoperability may take time to develop. Absolutely right. I think what I'm saying now is that we're moving forward. This is the time, I use the phrase again, it's a tipping point. This is the time to move forward into the digital world. There will be there may be a conflict of laws because that's exactly right. What we're trying to do is to create, if you like, an English law negotiable instrument, but you do need to check that whoever is involved, be he the drawer, be he the drawee, be he the acceptor, be the endorser, that he can comply with his obligations in his own jurisdiction. Somebody asks, how will the UK regulate reliability of electronic records? Good question, because that is reliable system. That is the test for all of us, because what we need is exactly the same acceptability of an electronic record in a reliable system as you have with paper. But remember, somebody just commented, an empty box is an empty box. A forged document is a forged document. A forged electronic record would be a forgery. So the verification process that is needed will always remain the same. And that's pretty important to remember that, because if you get careless in a move to an electronic record, you haven't solved the problem. You solve the problem of speed, but remember what goes with speed is making sure you can check within the time. And that was a point I accepted within the human element, that you still need to check these points. Thank you for some very interesting and challenging comments and questions. I hope I have answered them satisfactorily. I've achieved, I think, what I set out to do, which is to finish my presentation on time, which I've done so. Thank you very much for your attendance on that. If you have any other comments, feel free to email me or anybody else in Sullivan and Worcester. If you have any suggestions for future webinars, let us know. Otherwise, I hope you have a happy summer moving towards digitalization. We look forward to seeing you at the webinar in September, and we look forward to seeing you on anything else that concerns you in due course. Have a happy summer. Thank you very much.